and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. It seems like only yesterday.
And it was only yesterday, so that'll be why.
It seems like only yesterday. But yep, here's another one.
We are here for another Newsflash. This one, which is nice for me because it's local to me, but it's Cotham School and Bristol City Council and others. And it's a High Court decision from the 10th of June. And it's been quite a long-running dispute, which I know we've spoken about before in some courses, but I don't think we've done a podcast. Mm-hmm. So do you want to start with some background on this one?
Yes, you'll know Cotham School.
I do indeed.
Cotham, Bristol.
Not far from where I live.
No. And they've been around since 1856. But in 2011, they became an academy under the Academies Act 2010. And they also needed some playing fields. As you know, it's in the middle of Bristol and there's not much space there. And they acquired from the council a long lease of 22 acres, 125-year lease up at Stoke Lodge. Do you know Stoke Lodge? Right, far north.
No, I don't think so.
It's almost in Shirehampton, that kind of okay. If you know the area.
I do.
But this Stoke Lodge playing fields, this was in 2011, but the locals would go onto the land, and the school seems to have been concerned about various things and a safeguarding having the public close to changing rooms for the kids and the likes. And also dogs doing what dogs do on the land. And the other thing that they mentioned was the possibility of pupils absconding from this playing fields, which was open. And so the public seemed to be just turning up all the time. And they stopped actually using the playing fields because of the sort of safeguarding issues in 2014 to 2019. When they put up a 6-foot fence. They had all various signage up by various access points and the likes that shouldn't be trespassing. But they put up this fence. Before that, the locals had been, or a group of the locals, there was various pressure groups. The Stoke Lodge, We Love Stoke Lodge, that was one of them, and the Stoke Lodge playing field, Stoke Lodge Parkland group that were sort of trying to argue that you can't do this, and they put an application for a village green. They put an application for village green back in 2011, and eventually in 2016 there was a public inquiry, and also the inspector at Bristol City Council recommended it shouldn't be a village green. If it's a village green, then you're very limited in what you can do on the land, which I'll perhaps mention shortly. But they recommended it shouldn't be a village green as the user was not as of right, which if you want me to, I'll explain shortly. But nevertheless, the council registered the village green. There was then a case back in 2018, before we started doing these podcasts, a judicial review case, and the court there decided that I shouldn't have registered, it was deregistered. But the process went plodding along, and in 2023, the council once more registered this land as village green, and Cotham School brought this case arguing that the register should be rectified. So in section 14B of the Commons Registration Act of 1965, very rarely used, but it should be rectified, and the registration taken off. And that's what it's all about.
So you mentioned village greens. Can you go into some of the background law in relation to that?
Yeah, we've mentioned this over the years, Lizzie. Basically, you can register a village green. I'll paraphrase it. It's under Section 15 of the Commons Act of 2006. And it's where a significant number of the inhabitants of a locality or in any neighbourhood in the locality have indulged as of right in lawful pastimes or sporting activities for at least 20 years, and they've got to continue to do so. They can cease the activities a year before they make their application, and it can still, or 2 years if you're in Wales, and they can still make a claim, but that's basically it. Shall I give you examples? It wasn't what this was about, but what lawful. It's not just what people tend to think of. It's not just people playing cricket and football and rugby and the likes. There's cases galore. Most of them involve dog walking. There's obviously dog walking going on here. There seem to be dogs in this country prepared to swear under oath that, when I was a puppy, I was walking this land. You have to be a 20-year-old dog. I think it's different dogs. I can think of sledging, not in the cricketing sense, but feeding the swans, that was one of them. Various other egg rolling contest. It can be quite diverse. But if it is, I probably should mention what as of right means. As of right means it's without forced secrecy or permission. If you're trespassing, if you're given permission to be on the land. If you're secretly dog walking, then you can't claim village green. The significance of it being a village green, there's a couple of 19th century statutes that are still in place. Section 12 of the Enclosure Act of 1857, which says it's illegal to fence village greens, amongst other things, or to drive cattle or lay rubbish on the village green, or to spread manure, as I recollect. That's another one. So if you've been doing that, Lizzie, you must stop right now. And also anything which interrupts the use or enjoyment of the place as a place of exercise or and recreation, and there are criminal offences attached. You can't fence off the green, you can't build on it.
So what was the judgment in this case?
Well, there was we did mention it, I mentioned it in courses last year, because there was a preliminary issue that one part of the City Council was neutral, the Public Rights of Way Committee, and the other part of the City Council was favouring the school and supporting the school. And the initial case, the judge decided you can't do that. There's nothing wrong with two different branches of the council stating opinions, but they've basically got to be the same opinion. But we finally, as you mentioned, on June the 10th, had the final first instance decision, if you like. And it's a long one. It's 40,000 words. I've read every last one and memorised them. The most important reason for the decision is something we talked about before, and that's statutory incompatibility. If there's a statute which is incompatible with you claiming village greens, it can't be a village green. We did cases in a podcast, not so much news flashes, but a couple of late 2019 Supreme Court case, which were two which were joined together, which was Lancashire County Council and the Secretary of State for Environment, Food and Rural Affairs, and NHS Property Services and Surrey County Council. One was a hospital in Leatherhead, or Woods, next to a hospital, and the other was next to a school in Lancaster, fields which were next to a school. And they couldn't be village greens because it was incompatible with statute. And the judge decided this was also incompatible with statute. Under a statutory obligation to provide education for the children. And it was irrelevant that it was an academy, not run by the local authority. The second is that there have been signage put up at the access points, both pedestrian and vehicle access points, basically warning you that if you're on this land, it's a trespass. They seem to have been there a long time. They must have been a long time because apparently a lot of them were under the name of Avon County Council, which disappeared, to be replaced by Bristol City Council and a few others in 1996. And one or two of the signs have disappeared over the years. The judge decided it's irrelevant that, you've got the wrong, you're still referring to Avon County Council. These people, the vast majority of people would walk past these signs and known that they shouldn't be there, so it wasn't user as of right. Thirdly, they said that also you'd have known that the school's objections at the time of the public inquiry and the initial decisions and likes in 2016. They said there was nothing in the school's lease from the council that stopped the school stopping the public use this land for the public purposes. But if there was, it would be permissive. You'd be there under permission, and you can't claim prescriptive rights generally, including village green, if you've got permission to be on the land. Fifthly, there have been a couple of Supreme Court cases, one of which we definitely did a podcast on, a case called TW Logistics in Essex County Council, which was all about, it was a key in a place called Mistley on things on the River Stour in Essex, and whether the locals could use the land for their activities. Chatting was one of them, chatting and feeding swans, and crab fishing, which you could say in a different expression, but that was the other one. Because, these lorries, these forklift trucks were loading and unloading boats. And the Supreme Court said there should be give and take, you can both use the land so it can still be a village green. The judge decided here it was more than just having forklift trucks going across the land and dodging the locals. They would be displaced, and with the school. And sixthly, something I didn't know beforehand, it's Section 547 of the 1996 Education Act, which says if you're on school premises without lawful authority, it's a criminal offence to cause a nuisance or disturbance on school premises. Bet you didn't know that. And you can't base village green claims on criminal offences because it's going to be a lawful pastime or sporting activity. So for all those reasons, the village green claim failed. And the register, for only the third time ever under the Commons Registration Act, Section 14B, will be rectified to remove the village green. And that's it. Not quite. I think
that to say.
Well, the judge, His Honour Judge Matthews, did finish off by saying, "I'm under no illusion that the dispute within the parties will not stop here." Yeah, so I think We Love Stoke Lodge might proceed further. They are considering an appeal.
So it might not be the last we speak of it then.
Well, we might be talking about it again in a couple of years' time.
Excellent. Well, thank you very much for that, Richard.
Thanks a lot, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.